Now, having seen what the view of the Court of Justice of the EU is regarding the issue of long-arm jurisdiction of the national courts in the EU, let's turn to the Unified Patent Court, which is a new court in Europe, which has been up and running for almost 1.5 years now. And it had a case, the case we're going to look at today, where it had also to decide the question of whether, as a unified patent court, a European unified patent court, it can also exercise its long-arm jurisdiction or not. And this was a decision which was delivered in the 28th of January this year. So this is a relatively recent decision as well, where the two parties were, on the defendant's side, Kodak, and on the claimant's side, Fujifilm. This patent that was a part of the proceedings here was again not an SEP, but as I said already before, this does not make any difference because these rules apply also on SEP cases independently of the nature of the patent. This patent particularly was an European patent which referred to printing plates. And we had here two designations of the European patent. So it was enforced in Germany, which is a UPC member state, and an EU member state, of course. And it was also enforced in the UK, which is no longer an EU member state and also not a UPC member state. So here we had this connection, let's say, between the UPC jurisdiction and a jurisdiction which is, or a country which is outside of the UPC territory. So Fujifilm filed this lawsuit before the UPC in October 2023, and it asked for remedies, including an injunction for the infringement of the German designation of the patent and also the UK designation of the patent. Then Kodak raised an objection here, contested the jurisdiction of the UPC regarding especially the UK part of the case, by saying basically the UK is not part of the UPC, is not part of the UPC territory, so the court could not have jurisdiction for this part of the dispute. And what was also interesting here was that Kodak filed a counterclaim for revocation of the patent before the UPC. So it did not only contest the jurisdiction for the infringement action, it also counterattacked by asking the UPC to revoke the patent in suit here. The result was the decision that we're looking at today from the 28th of January 2025, and here the court dismissed the action. It dismissed the action not because it believed that it does not have jurisdiction, but because it found that the patent was not valid. On the contrary, the jurisdiction of the UPC to decide the case in general was confirmed by the court here. And we're going to focus on this aspect and look at the reasoning of the court regarding the jurisdictional issue. Now here, if we look at the provisions that the court applied, we will see that it was very similar to the decision that we discussed before of the Court of Justice of the EU. And similar was also the questions that were raised here. So with respect to the infringement in Germany, with respect to the German designation of the patent that was asserted here, there was not much discussion on the jurisdiction. So it was confirmed because also Kodak, the defendant, did not raise an objection here. And this was more or less the case also with the CGEU. If you remember, the Swedish part of the proceedings or the Swedish patent was not, jurisdiction was not contested regarding that part. Here we had, however, the difference that also infringement in the UK was asserted. And as we said already, UK is not a UPC member. So we had a similar situation here, where the question was whether you would have this long-arm jurisdiction, extend your jurisdiction for the infringement of rights that have not been granted in a UPC member state. or that or refer to a country which is not a UPC member state. So the law is the same, more or less. So the UPC applied also the Brussels 1 bis regulation here. And this is clear because the UPC as a court is also bound to European law. And in this case here, we had a case with an international link, basically, because we had also this UK part. So it should be clarified how to deal with the situation where you had an element of the case which was international in the sense that it was referring to a non-UPC territory. And the basic provision that was discussed here as well was the provision that we've seen before in the CGU case, Article 4 of the Brussels 1 regulation, which applies also with respect to the UPC. Again, the principle here is that the court in the region where the defendant is domiciled has jurisdiction. This is the principle. So the jurisdiction follows the defendant, as it is the case with the CGU case we saw before. In our case here, all three Kodak subsidiaries that had been sued were based in Germany. So this meant that this is UPC territory, and this is also the Duesseldorf local division that decided here. So jurisdiction was confirmed based on that. Now the question here was, does this Article 4 also apply when we have situations that refer to non-EU states? So when you have relations to non-EU states. Because if you remember, we said the Brussels 1 regulation generally, it tries to set up rules to solve conflicts when you have different courts of EU member states potentially having jurisdiction over the same case. Does this apply also when you have a potential conflict between a court in the EU, which includes the UPC here, and a non-EU court? And here the UPC referred to the CGU case law in a case called Ovuzu, and reminded the parties that the Brussels 1 regulation in general and Article 4 establishes universal jurisdiction, meaning that this international element that you need to have, so relations involving different states, is not just different EU member states, but it can also be a link to non-EU member states. So you can also apply the Brussels 1 regulation, including this basic principle established in Article 4, in cases where you have links or relationship involving EU member states or the EU and non-EU member states, which in our case is the UK. So this is the view of the court here. And the consequence of that is, according to the UPC, that Article 4 can be extended to the infringement of European patents committed in all the states for which it was granted. So again, long-arm jurisdiction established on the defendants. Where the defendant is located, you can file a case. And in these proceedings, you can extend the jurisdiction to all European patents and the infringement of a European patent in all member states where you have national patents that are based on this European patent. One reason for that is something that very similarly to the CGU, that the CGU also similarly mentioned, is this concept of efficiency or procedural economy. Because here the UPC also said that the patent owner should be allowed to bring all or his or her infringement claims before a single court and obtain a comprehensive relief from a single forum. So again, this benefit that you have when you have all disputes settled by a single court, which the CGU mentioned in the BSH case, seemed to be also a reason why the UPC seems to believe that this long-arm jurisdiction should be given here. And what is more, the court also said that the UPC when it comes to its jurisdiction. It cannot have less jurisdiction than the national patent infringement courts. And if you remember, we've seen already that a national court in the EU can have a long-arm jurisdiction, can extend its jurisdiction to the infringement of patents granted abroad. So the UPC said here, if you look at the Brussels I regulation, and you cannot argue that the UPC should be less competent or has a narrower jurisdiction than what national courts are allowed to do. So this was also an argument for saying that a long-arm jurisdiction should be given in the present case. The final element of this decision was the question of whether the court would have jurisdiction here for the revocation counterclaim. So if you remember, we said that Kodak did not just contest the jurisdiction of the court to hear the infringement case here, but it also filed actively a counterclaim asking the UPC to invalidate the patent. And the question is, does this jurisdiction exist here? Because we are again having this UK link. So we have a part of the patent, we have a UK designation of the patent. Is this revocation action impacted by that, or is the jurisdiction of the court of the UPC impacted by the fact that the infringement proceedings also involve a UK part and a UK patent? Now, the court found that this was not something that would stand into the way for the revocation action here. Basically, the court has jurisdiction, the UPC has jurisdiction to hear revocation counterclaims. And in the present case, as Kodak had filed this revocation action, the revocation counterclaim, it had sought a revocation in all UPC member states in which the patent is in force. And this was only Germany, because we said it was the patent was validated in Germany and the UK, and the only UPC member of these two is Germany. So basically, the court did not have to deal with the revocation of the UK patent at all in these proceedings, based on the action that Kodak had actually filed here. There was an attempt to argue that the UK patent would also be impacted by the revocation action before the UPC. There was, particularly Kodak apparently tried to argue that the claimant, the Fujifilm, should be basically requested to abide to the UPC decision and then consent to revoke the UK patent to the extent that the UPC would order. So here there was an attempt by Kodak to say that, look, although we're not really in the revocation proceedings of the UK patent, you should oblige the patent owner to accept your decision as the UPC regarding the German designation and oblige him to consent to change the patent respectively also in the UK. Now, the court, the UPC, found no legal basis for this request, and therefore it found that at the end of the day, the fate of the UK patent was not going to be impacted at all by the decision of the UPC. So the UPC would not decide on the revocation of the UK patent, and therefore there was no conflict here that would prevent the court from moving on with this case. So generally, the court confirmed, therefore, the jurisdiction for both the infringement case and also the revocation counterclaim. And if we look at that, compare this decision to the case we have seen before at the CGU, we will see a very common reasoning or a very common thinking of the courts regarding this issue of the long-arm jurisdiction. Now, a final comment here. This is a decision of the UPC in the first instance. So it could be, of course, that there will be an appeal in these proceedings here, which eventually would cover also the jurisdictional questions. Whether this appeal would lead to a different result, whether the UPC Court of Appeal would have a different view, is questionable, especially due to the fact that in the meantime we have also the CGU decision in the BSH case, which we've seen before, which takes a very similar position. So, although we don't have an appeal decision here, for the time being, it seems that it will be very unlikely that this will be overturned, especially in light of the CGU decision in the BSH case, which to which the UPC needs to abide with. It needs definitely to consider.